questions to do that, I've allowed ministers to use that statement or allegation or alleged statement at the start of a question and simply refute it. And that is to me the discipline on members asking questions, because they don't get any answer if they do that sort of thing. Honourable members, that does bring to a close questions for oral answer today. I have received letters from Dr. Russell Norman and from the Right Honourable Winston Peters seeking to debate under Standing Order 386 the requirement that the Minister for Land Information and the Associate Minister of Finance must reconsider their decision to approve Milk New Zealand's application to buy the Crayford Farms as a result of a decision of the High Court on 15 February 2012 and the outcome and effects of the decision on current government policy. The urgent debate procedure is a means of holding the government to account for matters that have actually occurred. It is not a means of debating something that may occur in the future. There's no ministerial responsibility for the decision of the High Court, as I pointed out to the House yesterday. So there's no ministerial responsibility for the decision of the High Court requiring that the Minister's decision be reconsidered. As that reconsideration has not yet happened, there is no particular case of recent occurrence which can be raised today. The application is therefore declined. I call on Government... point of order, the Right Honourable Winston Peters.
Speaker, this is not to in any way challenge what you've just said, except to ask you that yesterday, in your comments about an application, a similar application made for an urgent debate, you said that there were grounds that you could envisage an application being made, but they were not the grounds that were laid out in yesterday's application. That being the case, I'm not certain of what Dr. Norman drafted, but I know that our application was drafted not on the basis of what the court had said, because no minister is responsible for what the judge might do, but the results of that, which left the policy void on a matter that's highly political and of great public interest. That's why ours was phrased that way. Now, that said, you've ruled it out. But are there any grounds at all on which such an application could be successful, given what you said yesterday, which sounded like an invitation to lodge an application today?
I appreciate the right honourable gentleman's point. It's a fair point of order. The grounds that I envisage would be if the ministers made a very prompt decision to do something, and because that would be a case of recent occurrence. But the case must be something that is the responsibility of a minister, and as the right honourable member points out, that the decision of the judge is not the responsibility of the minister, and the member did put some effort into trying to frame an application to try and bring it meet the standing orders in it, and that was and I compliment him on that. But it does require a case of recent occurrence involving a government minister, and that hasn't happened yet. That was what I envisaged might happen. It hasn't happened yet. I call on Government Order of the Day for the address in reply debate.